Last matter to come before the court this morning is Chuparkoff versus Ohio Title Loans.
Thank you, Your Honor.
Thank you. I'm sure you have 15 minutes in which to present your case.
Thank you.
You have read your briefs, we're ready to see where you are.
Thank you very much, Your Honor. The court, thank you for listening to me. This appeal, my name is Ted Chuparkoff. I happen to be the appellant. I happen to be the counsel of record. This is a very unique situation, a very unique case, which I think has tremendous concern to the state of Ohio. By way of background, in 2016, a vehicle in my possession was taken off my private property during the night. This vehicle was not titled to me. I will make that clear. But I did have custody of it because it belonged to my son. Now, in this vehicle, I had personal property. Most importantly, I had private legal files in this vehicle. Very personal, very confidential, that can never be duplicated because some of the documents in every legal file contains information given to the lawyer by the client that's secret between the client and the lawyer, whether they be bank records or confessions or anything else. Now, the law says, and the statute says, that the company that repossessed this vehicle was required to notify the owner within 20 days and to give him 10 days or a minimum of 10 days to recover his personal property. The defendants were sent a certified letter requesting an opportunity to remove their personal property from this vehicle. It was a certified letter with a return receipt. They didn't do that. So the plaintiff, the custodian of the vehicle, filed a lawsuit, and the defendants don't file an answer. But in any event, the plaintiff requested that he be given a judgment for compensatory and punitive damages for the conduct of this company who repossessed this vehicle by transgressing on private property. They ignored the letter, ignored the request, and the lawsuit was filed.
Can I ask a question? Did they notify your son, because he's the one that owned the car?
Yes. No, they did not. The testimony, I'll get to that, no, they did not. That's the problem.
They never notified him that he had 20 days to retrieve his
Yeah,
stuff.
that's the problem.
And the letter was mailed by you to Ohio Title Loan?
It was certified, I don't know that I mailed it or he mailed it, but he signed it, he signed it, and we got the return receipt. There's no question, he sent the letter under his name to the mortgage company.
And was all that presented as evidence in the trial?
Yes, absolutely, and I want to get to that. That's the important part. So we were granted a default judgment, claiming that the defendants went on private property, took this vehicle. Now, they may have a right to do that. That's not what we're arguing. They could have a right to do that. But they had an obligation to remove, to replace, and return the private property that did not belong, was not part of the vehicle. Now, they don't file the answer, and so we get this judgment, and the court sets it down for damages. A magistrate, with all due respect, took the place of the court. We don't have any trouble with that. At the hearing. And the only witness to show up was me. And like any other witness, I was obligated to raise my hand and swear to tell the truth. not realizing, unfortunately, and I regret to say this, not realizing that the greatest adversary in the room wasn't the court. The court ends up saying that there was no evidence presented in any one of these cases and didn't grant any damages at all. And so I raised the question. I was always under the impression if a person raises his hand and swears to tell the truth and answers questions under oath, that's considered evidence. I swore under oath that a certified letter was sent to them and I introduced the receipt. But the court ruled there's no proof that the defendant actually signed the receipt or they actually got the notice of it. The only witness, me, testified that in that vehicle was a door, a garage door opener, access to the house that I live in. And that was confiscated by them. So these strange people, whoever they were, got the key to my house. And all they had to do was to give me 10 days to get my key back. And what happened? I testified that I got an estimate it would take $400 to replace the mechanism. For some reason, that wasn't evidentiary because I'm only a lawyer testifying under oath. That's what it was going to cost. For what it's worth, I'm trying to establish the fact that I did have an interest in this, and at one point, I know that the day that it was repossessed, I personally put $25 worth of gasoline in this vehicle. Now they say, well, you know, that's come out, but you are over $25. We're not here for $25. We're here because the court said the court did not believe I put $25 worth of gasoline in that vehicle. I should have had more evidence. Well,
did you have a receipt for, or estimate for the $400?
No.
Just your testimony.
No, I did not have a written receipt. All I'm testifying under oath that I inquired about an estimate, and the quote was it would take $400 to replace it. Nothing sophisticated about that. I couldn't get it done free. They took it, I couldn't get it done free. Now, I also testified that I spent a couple of $3,000 fixing this vehicle up. Now, admittedly, I made a mistake because I got a little careless when you're the only person in court putting on evidence and there's no adversary, you get a little careless. But the truth of the matter is, I established without a doubt that I spent over $3,000 fixing up that vehicle. Why did I say that? Simply because I think the most significant thing about this case is that a message has to be sent. You can't repossess people's property on private property at night, take the vehicle and keep their private property, ignoring the law that says you got to give them a chance to get their personal property back. Here I have strangers having a key to my house, walking onto my driveway, my garage, the garage door was open, taking this vehicle. But most important, I can't place a value on those missing, stolen files of my clients. And the law requires me to keep for at least 7 years. What do I tell these people? What if they want to change lawyers? What do? I couldn't even reconstruct them if I wanted to. Sure, I can go to the internet and get the pleadings, the motions and all that, but that doesn't complete the file. So as I stand here today, somebody stole my legal file that is very confidential information, and there's got to be a message sent. You can't do that. You may have a right to go on people's private property. You may have a right to possess the vehicle, repossess the vehicle, but you have an obligation to make sure they get their personal property back. How could it ever be that you repossess a vehicle when there's only nothing in it? All property has personal property, no matter how large or how small. Now, the amazing thing is that when all said and done, magistrate, with all due respect, that I didn't prove any damages. I didn't prove I put money in the car, I didn't prove they stole my door opener, I didn't prove anything. I didn't even prove I sent the certified letter, although I sent them the receipt. As a consequence, there were no damages. So I filed an appeal to the court. And the judge, the trial court, supported the magistrate and gave, I think, $100 worth of damages. $100. Or I'm not even sure of that amount, excuse me. $10, I'm sorry. $10. Now, first of all, they're either damages or not damages. How do you get a $10 worth of damages? I mean, I think it just defies common sense and logic. My point, I'm here because, let me tell you, it ain't the $10. It ain't the $400 door opener. This court has to send a message because there are poor people in the state of Ohio that don't have a lawyer where they can afford to pay a lawyer to come and say, hey, look, they took my personal property. Because most people get their vehicles repossessed, and as a consequence, they're stunned. How arrogant could the defendant be to take this vehicle and pretty much say, too bad? Now, I tried to establish in this case that the vehicle that was taken had a retail value of about $10,000. It was not intended to prove, nor did it say that as a consequence, I, not the owner of that vehicle, was entitled to the difference because it was a $1,500 lien on the vehicle. I wasn't asking for the $8,500. What I did was, I went online and I got a very similar article of the vehicle. And I made reference to that vehicle to tell the court these cars are worth about $10,000, and I gave the PIN number. This magistrate unfortunately made a mistake, and she said it was a different PIN number, it's not the vehicle that was repossessed. Of course it was a different PIN number. All vehicles had different PIN numbers. She didn't understand what the PIN number was and the purpose of the PIN number. So in any event, Your Honor, I just believe that I'm here, and I hope this court agrees that there was evidence. Now, if you don't want to believe the evidence, fine. But to say there was no evidence when somebody takes the stand, swears under oath, that's always been my understanding of the law. You may not believe it, but that is evidence to be considered. And at one point, the magistrate said there was some evidence offered, but then when it comes to damages, there weren't any. I do believe that at this point in time, the message that the trial court has given, that if you're in a predicament that Ohio title is in, you're better off not filing any answer. Because what happened in this case, the magistrate took the place of the defense lawyer, disbelieved everything I said. And she had no right to do that. She's not an adversary. She's not supposed to prosecute. She never even had to, I hope she would have asked me some questions. If she would have lived in doubt, all she had to do was ask me, and I would have tried to clear up the point. But she sat there, and I just got to be careful. I cannot escape the fact that she sat there for over an hour, and everything I said, she basically said I wasn't telling the truth. I don't know how you do that. I'm sorry. And I just hope this court realizes that somewhere in the state of Ohio, in the 88 counties, when a title company repossesses a vehicle, you got to give them a chance to get their stuff back. They have to give my son a chance to pay the $1,500 to get his $10,000 car back, but they didn't do that. Who knows what they did with the vehicle? They may have sold it for $9,000, $8,000. They never gave my son a chance to buy it back. If that doesn't qualify for punitive damages, what does?
Well, the fact that you weren't the titled owner to the vehicle, didn't that play into the court's decision on that issue?
We shouldn't have. Let me tell you why, Your Honor, if it pleases the court. When you assess punitive damages, you gotta consider the consequences of what the punitive damage should be.
Was there
I'm not-
evidence of fraud or malice here that would?
I'm sorry?
Was there any evidence presented on your part to show fraud or malice that would form the foundation for punitive damages?
Well, they never gave them an opportunity to repossess the course. When you don't give the owner a chance to recover his personal property, that's a deliberate act. What if there would have been a $50,000 wristwatch in there? I mean, no, of course. What they did was punitive. They did not give an opportunity to regain, to buy it back.
The court in its entry concerning the unjust enrichment stated as follows, that you did not argue or otherwise raise the issue of unjust enrichment at the damages hearing or in his complaint or in the motion for default. Would you agree with that or not?
Would you repeat that one more time?
The court in its entry stated that you did not argue or otherwise raise the issue of unjust enrichment at the damages hearing, in your complaint, or in the motion for default.
Absolutely not. Why do they think I was talking about, of course, unjust enrichment? When I raised the issue that they unjustly enriched themselves because they stole a vehicle that didn't belong to me, I just wanted to know that. It wasn't my vehicle, for what I could have made a different kind of argument. But they unjustly enriched themselves.
And you raised that at the
Absolutely.
damages hearing, the record will support that.
Yes, sir.
Okay.
Thank you.
I thank you very much for listening to me.
Thank you for your presentation today. The court will take the matter under advisement and issue a written decision which will be mailed to you on the other side. And the court is adjourned until Tuesday, October 2nd in Summit County.